Welcome to the Expert Network Team podcast,
where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business nature.
We hope you will find our content useful as well as entertaining. The Expert Network Team consists of Carl Frank of A&I Financial, Mike Miller of Miller and Associates CPAs, Jeff Cromendike of Security First Insurance Agency, and I'm Nathan Merrill. I'm an attorney at Goodspeed & Merrill.
Together, our independent team combines our expertise to provide you insights and solutions, some straightforward, some profound, for real-life opportunities we see on a daily basis. We hope you enjoy the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
We encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Now on to today's podcast.
Welcome to today's podcast. I'm Nathan Merrill. I'm an attorney at Goodspeed & Merrill, and I'm here with Carl Frank of A&I Financial. And we have a special guest with us here today from the offices of Goodspeed & Merrill, our very own Leia Ursery. And Leia runs our trust and estates practice. And I'll let her give a little bit of background on kind of what all constitutes our trust and estate practice at Goodspeed Merrill. But I am in her group, and I'm pleased to be able to work with her on a daily basis. And she's just an exceptional attorney. And I think today we're going to focus on talking a little bit about probate and trust administration in Colorado. So Leah, why don't you introduce yourself a little bit? Tell us a little bit about your background.
Sure. Thanks, Nate. Thanks, Carl. I'm happy to be here today. As Nate had mentioned, I joined Goodspeed & Merrill a few years ago with the idea of coming in to head up the trust and estate practice group. When someone asks me what that entails, it's kind of a little bit of hodgepodge of everything. The easiest way to think of it is what are the documents and what are the processes that are involved when somebody becomes incapacitated or disabled. That's part of our practice. And it's also more commonly referred to as what happens when I pass away. How do I get my money and property where I want it to go? And how do I select the people that I want to be in charge of that process? So when we think of a trust and estates practice, it is the planning component of it, the drafting of the documents that spell out your wishes, your goals. It's also the after part where it's the trust and estate administration, advising fiduciaries on how to appropriately handle an estate administration, the administration of a trust. If a person does not have appropriate documentation when it comes to disability or incapacity, it could also include a guardianship or conservatorship type of proceeding, which we can talk about at some point. And then also the litigation that comes up in that area. What if we believe that a fiduciary, meaning like a trustee or an agent, a personal representative, has done something incorrectly? How do we take measures to have a court review that process? If we think that a document is invalid, that would be generally referred to as a will contest. That's a common proceeding. We deal with a lot of common law marriage claims. Never do we have as many common law marriage claims as when somebody passes away and sees a pot of money there to be divided. We tend to have some common law spouses that come out of the woodwork, and the estate proceeding is the context that is usually dealt with.
Yeah, and then we did, Carl and I, if you recall, Carl, we a while back did a couple of podcast series on wills, putting together wills and trusts and doing the estate plan. I'm using air quotes here. We're doing the estate plan in terms of putting it together and the powers of attorney. So this is the missing link in all this is really what happens when you die. So maybe you can begin there, Leigh, and talk about kind of when you get the call when someone's loved one has passed away, kind of what are they expecting, or what should they expect? What are your first steps?
Well, in terms of the first step is to figure out where are all of our pots? Where is money owned? How is it owned? What is any kind of setup mechanism in place already that can help make sure that the property is getting where it needs to be without maybe the involvement of the court or anything in a formal context of a trust administration. So one of the first questions that I will ask somebody when they are involved in this conversation is, what did the decedent own and where is it located? Where are we going to need a probate administration, if any? And by way of default, probate is typically only going to be required if a decedent passes away with property in his or her name alone, without a joint owner, without a paid on death designation. Jointly owned property is commonly referred to as non-probate assets. That means when property is owned jointly and one of those joint owners passes away, title to the property automatically passes by operation of law to those surviving joint owner or owners. Now, we do have to be cognizant of, just because somebody else's name is on an asset, it doesn't necessarily mean jointly owned property in the sense of joint tenancy with a right of survivorship. We also need to decide, is it tenants in common, meaning that automatic right of survivorship does not attach, and therefore we might need a probate to be able to clear title. Similarly, if you've got an asset that has a paid on death designation, and most commonly that's going to be in the context of like a retirement account, life insurance policy, significant investment account, those are also non-probate assets, meaning that those designations on file with the company will automatically control where that account goes, where the proceeds are transferred. And the beneficiaries would deal with those institutions directly. So probate is really going to be needed if we've got a situation where a loved one has passed away and they have a piece of property, a bank account that has a greater than 70,000 or so value to it, a car, potentially other significant assets with value that is in their name alone, with or without a joint owner, without a paid on death designation.
So one of the things that I always find interesting is, so all that stuff makes sense: financial assets, homes, cars, all that stuff. Do you, when someone comes to you that week of or that day of, what counsel do you give them regarding the other stuff? Because I know that's one of those things. It's like the sticky hands start to come out and things start disappearing, jewelry, valuables, other sorts of things. How do you address that?
Sure. Well, one of the first things I will tell people is take a deep breath. We cannot handle everything all at once. Inevitably, you're going to end up with a to-do list. And part of that battle is just attacking the to-do list on a case-by-case basis. Now, when it comes to the sticky issues, the movable, tangible personal property, the cars that may be continued to be driven, the person who is nominated as the personal representative or successor trustee under a revocable trust would be the person with presumptive authority, even without a court proceeding in the context of an estate. They are the ones there to go and safeguard. So, I will usually tell them that if there are any items of significant personal value, that we want to make sure that those are locked up or at least kept safe somehow. If there's a car, we want to make sure we know where all the keys are. We would like the car to be somewhere where people cannot get readily available access to it. If there are firearms, especially if there are firearms that require a special license, we need to make sure that there's somebody with authority to possess them in the interim. And if not, we actually need to contact the authorities to make sure that they can be turned over and held until somebody with authority has the ability to take possession. Illegal substances, we need to make sure if there are any of those around, make sure that those are taken into custody by the appropriate authorities if needed. So, kind of get an inventory. What is out there? What are we going to be dealing with? What are the issues that we have the most urgent nature to be able to deal with? Or what are the ones that are on the list and they'll get dealt with as time goes along? One of the common mistakes I think that people make, and understandably so, is they want to solve everything in the next 5 minutes. For better or for worse, when somebody passes away, if a probate estate is opened, there's a minimum of 120 hours that has to pass before an estate proceeding can be commenced. So there's that 5-day time period where there's really nothing you can do. You kind of just need to collect your thoughts, start making some good notes, and then be prepared to file the paperwork with the court once that time period has passed by. But talk to the family members. Good communications can often avoid unintended consequences and actions. If somebody knows a person is taking the lead on safeguarding the assets and what are the plans for that safeguard, it will maybe encourage them not to poke their nose into that particular task and maybe start acting in a way that is contrary to what the global plan looks like.
Too many cooks in the kitchen problem.
Yes.
Right. Do you have any tricks about how to go about the inventory? I mean, do you usually recommend folks pull out the cell phone and start recording and taking a video kind of inventory along with what they might put down on a list? Or how do you usually ask folks, how do they go about that process?
That's really a family by family type of decision to be made. If we have clients coming into the office and everybody is clearly getting along very well, that is not as important to have photos of each and every item, the video of the house. In the families where you already hear a history of discord, that becomes even more important. If it is a family where it's not just a history of passive discord, but you know that there's a fight on the horizon, it may be worthwhile to go ahead and have a company, an estate company, come in and actually do an inventory along with an appraisal. So it's a scale. The scale from just simply kind of taking a quick down and dirty inventory, meaning identifying the big things with significant value, kind of grouping together everything that's more minimal, versus getting a very extensive, very detailed inventory with appraisal. Where the family falls will depend, but as the attorney, we kind of have to listen for our cues. If we start hearing stories of families where siblings have had a history of not necessarily getting along very well, that's our sign that we need to start advising clients to be a little bit more careful and a little bit more specific in their efforts.
Even going as far as like changing locks and.
Yep. Absolutely. Never a bad idea to change locks in general.
Well, yeah, these are really good pieces of advice. I'm so thankful to have your expertise, and certainly, in our financial planning firm, we've helped a number of people, are helping people now, and we can foresee in the future. What are some complications you see? Because this is a situation we're in often, where people are in a common law marriage. They don't even know that they're in a common law marriage. Especially, you had mentioned the legal phrase presumptive authority. Does this non-officially married life partner of a decedent, I mean, do they have power? And what about the rest of the family? Can we dive into that situation? It seems really common. I'd love to get some practical advice out for people out there who may be in that.
Sure. Well, Colorado is a tough state. I mean, we live in a state where a common law marriage can be created based on some pretty minimal circumstances. If you have a couple that is consistently introducing themselves as husband and wife, as spouses, if they're holding themselves out to the community on a consistent standard, that may be enough for them to create a common law marriage. When there is a question as to whether or not somebody is a common law spouse, the court's going to look at a variety of circumstances. Historically, we used to rely heavily on how tax returns were filed, where they filed single versus married, either separately or jointly. We had a couple of cases come out a few years ago, and it was mainly affiliated with the same-sex marriage issue, where couples were not legally able to get married under the eyes of the law. And so they were making arguments that even if they weren't able to legally get a marriage license, that they were common law married for years before that. And where that became important was the nature and extent of their rights when it came to elective share claims, et cetera. And what the courts came back in that time period is said, look, tax returns are important, but they're not solely determinative. And you have to look at everything in terms of, what did the community think? What did they hold themselves out to be? So if they consistently, again, introduce each other as a husband and wife or spouses, that's going to be some strong evidence that they consider themselves to be common law married. The other thing is we don't have a time frame, a litmus test here. It can be created very quickly. And that's not something most people understand. For example, I was contacted, I think it was last week, where an individual said, hey, I'm about to do a premarital agreement with my fiance. We're getting married in July, but we're going to go down to the courthouse and get just a quick little certificate, but we still don't plan to be married into July. And I'm like, no, that little ceremony you're going to do at the courthouse is enough. And people don't realize that. So when we have families that come in, what we will encourage is that if there is a circumstance that they believe there would be a claim of common law spouse, whether it is contested or uncontested, deal with it proactively. So for example, if we've got a situation where there is somebody who's either claiming to be or seen to be the surviving spouse, one of the things we can do as part of a probate proceeding is file the paperwork to open the estate, affirmatively assert that they are a spouse. If we do that process formally, that potentially forecloses any kind of later challenges to the status of that relationship for anybody who received notice of that process. If we have somebody floating around that is laying out claims of common law marriage that we do not believe are valid, then that is again where we might go into a formal probate proceeding and specifically say this is a companion or a partner and ask for the court to issue an order. We can strategically maybe get that foreclosed very early, and it takes away that potential claim, Carl, of to what degree does this person have a presumptive right to come in and start collecting assets or marshaling assets. So it's really going to be facts and circumstances in terms of how that's going to be dealt with. But that kind of goes into a separate statement. A lot of our clients will come in, especially after talking to their advisors, to say, I need a trust. I need to avoid probate. I need to avoid it at all measures. It's a timely, expensive process. And I can see where they're coming from. Revocable trusts are great estate planning tools. They work wonderfully when they work well, but a lot of us will be familiar that we'll have clients that come in that have revocable trusts and they never funded them or they never fully funded them. And we end up having to go through probate to get assets over to that trust potentially. But in Colorado, especially, our court system is set up quite efficiently for the probate process. I mean, for even people who don't want to deal with attorneys, there are very detailed instruction packets on the state court website about how a probate estate is opened if you have a decedent that had a will or not. But we can use that probate proceeding as a nice tool to deal with potential claims of common law marriage. Get that out at the first and deal with it proactively as opposed to reactively, especially after time has passed. We can also use that as a way if we believe there's going to be some issues with creditors' claims. There's some strategic ways to handle the probate proceeding to try to mitigate or eliminate potential creditors' claims that we don't necessarily want floating around.
It's something I want to emphasize there that you said earlier, just in passing, because I hear this a lot, is the assumption or presumption that you can't get common law married until 7 years or something like somewhere 7 years came into the equation and people are like, well, we haven't been living together for 7 years. So that's important for people to understand that there's no, like you said, litmus test. There's no hard and fast rule in terms of time that you're together before common law marriage. It can be established very quickly, very easily. And isn't one of the ways, I just want to confirm this, like if you get health insurance with your significant other, or if you have a life insurance policy naming them as kind of the spousal beneficiary, these contracts can create a presumption of marriage, can't they?
Yeah, whenever I'm the one looking at trying to advocate for a common law marriage, one of my prized piece of evidence that might come across my table is a health insurance form, right? Because many people will hold themselves out to be married for the purpose of getting health insurance. That right there is a great place. So when we've got a common law marriage claim, one of the first things we're doing is issuing a subpoena or writing to get records relating to life insurance beneficiaries, retirement plans, health insurance, et cetera, to say if the decedent or the protected person, if we're dealing in the conservatorship arena, to what degree did they fill out paperwork where they may have referred to what relationship they have with this person. And so that can be a very important probative tool.
And you mentioned that there.
Follow up on.
Oh, go ahead, Carl.
Real quick. Yeah, real quick. That's a really good question. What if you're a beneficiary of a trust?
In terms of which way, Carl? Like what?
In other
that
words,
creates a presumption of marriage.
You have your Yeah, exactly. So is that a way to? I live with this person, but we're not officially married. I want my kids to inherit my money, but I do want this person to inherit some of my assets. If she or he is a beneficiary on my trust, is that going to show up in probate?
It may be used as an argument to support, but it's not, in that situation, that alone being a beneficiary would not necessarily be probative. What I would be looking at in the estate planning document, whether it's a will or a trust, is the person's relationship described? So typically in a document like that, you're going to have a paragraph or an article that's talking about family information. So it'll say, I am married to, or I'm unmarried. Those are the kind of statements I'm going to be looking at. If it's simply a will or a trust that says, I hereby designate 45% of my property to be held in trust for this person, that in of itself is probably not going to be the influential evidence that we're really hoping for.
So, and that is a good segue to what my question was, which is, what is the motivation behind these posthumous marriage declarations? Like, why is someone doing this? Can you speak to that?
Sure. So under the Colorado Probate Code, if an estate proceeding is required, you've got a certain priority of people who are entitled to serve as a personal representative. So if the person had a will, we look at the will itself. Who did the person nominate to serve as their personal representative? If the person did not have a will, spouse is right there at the top. So if the person wants to be in charge of how things work and how things are handled, if they can successfully claim to be a spouse and the decedent didn't have a will, that's probably going to give them some priority to be in charge of the administration itself. From a beneficial perspective, if the person had a will, and let's say that the putative spouse, the person claiming to be a spouse, is not included, then there are statutory rights allowed to that person. So, for example, there is an exempt property family allowance that provides a spouse and potentially dependent children with a right to the first $74,000 of an estate, even before most creditors are claimed. The bigger ticket item would be the elective share. An elective share is essentially the rule that says, unless the spouse has agreed, you cannot definitively disinherit a spouse without his or her permission, meaning if they've signed a marital agreement, they can waive a right to an elective share. But if they haven't done that, and they're not included in an estate plan at all, or if they're given very little, the law provides that a spouse essentially has a vesting period over the first 10 years of marriage to kind of the big augmented estate, the big pot of money that would otherwise exist between the two spouses. For each year of marriage, the surviving spouse is deemed to have earned, so to speak, 5% of that big pot. Up to the 10th year of marriage, it's maxed out at 50%. Surviving spouse's assets first comprise that pot. Anything they receive as a result of the decedent's death then is contributed towards that percentage amount that they're entitled to. And then if it's still not high enough to get them to that threshold, they can make an election against the estate to get them the rest. And so that's where you might see a common law spouse claim come from. If there was sorry, go ahead, Nate.
I was going to say, how does that interact with trust? So say I set up an irrevocable trust or something with a life insurance policy, and a lot of people used to do that, 10, 15 years ago. Is that included in that calculation?
Probably not. And the reason why I say probably is that we do look at transfers within a certain amount of years of death. Those transfers can be brought back in, but life insurance and retirement accounts don't necessarily factor into that calculation. So the elective share calculation is very convoluted. Our statute was updated about 10 years ago by Lori Hunter, led the group effort on that subcommittee. And she did a really nice job of trying to clean up the categories and make the calculation a little bit more clear. But there's kind of buckets. There's the probate bucket, there's the non-probate buckets, there's certain assets that are exempted out of the non-probate bucket, there's the spouses bucket, and et cetera. And so you kind of have to go through this formula, and I have a spreadsheet that I've created to kind of make it a little easier, but you go through a formula to come up with the numbers, figure out what the bucket looks like, and then see how, to what extent this surviving spouse's share of the bucket has been satisfied, and are they owed anything else from the estate. Now, if they have a revocable trust, that's a non-probate transfer. Anything in that trust would be part of that calculation for sure.
Got it.
But
so what about?
Go ahead. Sorry, whoever wants to go
first.
first.
I was going to say this is so helpful. We have so many questions as we go through life. So there will be some people who want to be married but didn't go through the process, and so they would want that common law marriage. But it seems like a lot of people who don't want to go through the process don't want to be accused of being married as well. And so all of these planning concerns are important. And one of the takeaways that I'm getting from you is that there are certain advantages to probate that can help eliminate some of these concerns. And one of them right away could be the common law marriage question.
Yeah, and Carl, on that line, I mean, the probate, even though you can be proactive in that context, there's other during life measures that can be taken that can even be more beneficial from a proactive standpoint. If you've got a couple that have shared their life, they are committed to each other, but do not want to be married for one reason or another. And there could be a variety of reasons. Maybe their pension entitlements might be affected if they get remarried, et cetera. They could do a cohabitation agreement that simply says we are committed to being partners, even if we are living together, even if we have one or more joint accounts together. We don't intend to be married unless there is an actual marriage certificate or license out there that substantiates it. So that would be one example that would help foreclose that common law marriage argument down the line. But as long as people also too realize that the existence of a marriage is governed by each state's law. So if they were living in another state and that state had common law marriage, then they need to consider what was the basis for, or what is the requirements of common law marriage in that other state, because once they're married somewhere validly, even if they move, they're still married. And there's no such thing as common law divorce. Once you are common law married, you are married. And if you want to break that relationship up, that's where a dissolution of marriage or legal separation comes in.
So,
no such thing as a common law divorce.
No such thing as, yeah. So what are some of the other key elements of the probate process that people should be aware of, just so they can feel informed about this?
Well, to tidy it up, I will just tell people, don't be afraid of the system. I tell clients, and it's maybe a little harsh the way I word it, but quite frankly, the court doesn't care unless there's a problem. The court is there to process paperwork, to simply be able to affirm, did a decedent have a will? Did they not have a will? If they did not have a will, who are the persons entitled to receive the decedent's property? And who is the person entitled to be appointed as a personal representative? Now, there are some administration matters that come along with it. For example, within 30 days after somebody's appointed as being a personal representative, they are supposed to send out an information of appointment that says, an estate has been opened. I have been appointed as a personal representative. If you have questions, let me know. That goes to anybody who is either a devotee under a will, a known creditor at the time, or a potential heir if the will didn't exist. That is something that's required. A personal representative is supposed to put an inventory together within 90 days and either file it with the court or make sure it's available if any interested person requests it. But otherwise, outside of those requirements, if everything is moving pretty smoothly, the court really doesn't have that much involvement. It doesn't care. The only time the court cares is when there's a problem. And one of those common misconceptions I get when people come into the office is, I need to avoid probate to make sure nobody can fight. Well, let me just tell you, if people want to fight over something, they can fight regardless if a probate estate is opened up naturally or if it becomes a necessity. So, and what I mean by that, if a person has a concern about the validity of a trust document, they have a right to start a trust proceeding to challenge that document. So if they believe that a person might have been unduly influenced to sign a document, or they may have not had capacity to sign a document, all of those documents can be challenged in any context. Even if it's not a traditional probate estate proceeding, a trust proceeding can be commenced. If a creditor is owed money, from a strategy perspective, just keep in mind, we have a non-claim statute in Colorado that says if somebody's owed money, they need to file a claim for pre-death claims no later than 1 year following a person's death. If you've got somebody that's passed away and they had a revocable trust and everything was fully funded and things are working smoothly, but let's say they had a bunch of long-term care expenses or last medical expenses, and you want to cut it off so that the family is not having to look over their shoulder for the next year, you could open a probate proceeding, initiate a notice to creditors in the newspaper, which will essentially, if you do it timely, will cut it down to a 6-month time period as opposed to a whole year. So, you kind of have to look at it. Don't be afraid of the process. There's good and bad to everything. Probate is not, avoiding probate is not a magical formula to make everything move smoothly. it's a component that can help facilitate the winding down of somebody's final affairs. And it's not crazy expensive, like some people would say, especially if there's no fighting. If there's going to be a fight, it will likely be expensive. It will likely take a lot of time. And that is regardless of whether or not a probate was needed in the first place.
Phenomenal. Carl, is your head spinning?
Really helpful. I love it. I'm full of more confidence and ideas, and I really appreciate your sage advice today. Thank you so much.
Absolutely.
Yes. Thank you, Leia, and we'll have to have you back. I know there's many other topics on which you could inform our listeners and help them. So we look forward to talking with you again.
Perfect. Thank you.
Have a beautiful day.
Well, that's it for today's topic, Carl. Thank you for joining us as well, and make it a beautiful day.